Welcome, everyone. Thank you for listening to the Council of Institutional Investors, Voice of Corporate Governance. I'm Jeff Mahoney, General Counsel of CII. Our topic for this episode of the Voice of Corporate Governance is the apparent trend in corporate law that permits corporations to shop for corporate charters that have broadly eliminated doctrines that enable shareholder suits against directors and officers who turn a blind eye to corporate lawbreaking. And my special guest is William J. Moon, the J.B. and M.K. Pritzker Family Foundation Distinguished Visiting Professor of Law at the Northwestern Pritzker School of Law and the Edward M. Robertson Professor of Law at the University of Maryland Carey School of Law. Professor Moon is the author of an essay forthcoming in the Washington University Law Review entitled Havens for Corporate Lawbreaking. Welcome, Professor Moon. Thanks for taking the time to speak with us today.
Thank you so much for inviting me. It's a pleasure to be here.
Professor, in your essay, you describe the corporate law offered in Nevada as an example of a law-breaking haven. Can you explain what you mean by that and why institutional investors might be concerned about companies that incorporate or reincorporate in Nevada?
My main thesis is that Nevada, along with jurisdictions like the Cayman Islands, offer governance rules that significantly undercut the directors and officers' legal compliance obligations, which is important because it affects the risk appetite and law-breaking tendencies of corporations that can impact long-term shareholder value. So just to put that analysis into context, let's start with the corporate law that most listeners will be familiar with, which is Delaware corporate law. Delaware is often described as, rightfully so, a shareholder primacy jurisdiction, meaning that structurally the law facilitates managers to maximize shareholder value, and the law is structurally there to privilege shareholder rights. But it's also not a jurisdiction and has never been a jurisdiction that has embraced ruthless profit maximization in the name of advancing shareholder interests. The state, for instance, made it very clear that corporate fiduciaries may not engage in illegal activities, even if that illegal conduct results in more profits for the corporation. And if anything, Delaware has doubled down on its legal compliance jurisprudence in recent years through its widely publicized Caremark cases, where plaintiffs have survived a motion to dismiss, particularly where directors have completely failed to prevent a mission-critical legal compliance risk. Now, what we see in emerging competitors like Nevada is something different. For one, Nevada law immunizes as a default directors and officers for oversight failures that's predicated on corporate lawbreaking. This means that directors of a corporation incorporated in Nevada can presumably turn a blind eye to lawbreaking to predictably boost profits, without worrying about shareholder oversight or a possible derivative suit. While Nevada corporate law technically does prohibit intentional violations of the law, they have substantially narrowed what would be considered a colorable intentional violation claim and have erected powerful procedural barriers, including severely restricting shareholder inspection rights over books and records that constrain the ability of shareholders to bring claims even when directors and officers actively participate in lawbreaking. Now, we haven't seen a full-scale evisceration yet, but there is nothing that really precludes them from doing so. And there are several reasons to think why some form of legal compliance is desirable, even if we think about the sole purpose of managers as maximizing shareholder value. When corporate law scholars and practitioners speak of the obligation to maximize profits, most of us are not really talking about profit maximization in the short run. But we know that managers are under immense pressure in our capital markets to deliver short-run profits through quarterly and annual earnings report. And from that perspective, illegal activities can be conceptualized as a form of short-termism that we want to prevent through corporate law. That is, lawbreaking may actually be profitable in the short run, not just for the firm, but also possibly good for manager compensations, but arguably mission critical legal compliance failures are those that could cause severe harm that threaten the firm's long-term value and sustainability, which is something that institutional shareholders care deeply about.
Professor, as you observe in your essay, There was a scholarly consensus in the 1970s that Delaware was dominating the charter and corporation market because it had raced to the bottom. Later events seemed to disprove that thesis, and Delaware law evolved in a more stockholder-friendly manner without jeopardizing its primacy. But now the race to the bottom dynamic seems to have reemerged, with Delaware participating in that race. So, why do you think we're seeing a resurgence of this dynamic now? And what are some of the knockoff effects that you think we're going to see in the future because of this corporate law race to the bottom?
Great series of questions. And I do want to be very clear on the onset that I think jurisdictional competition in corporate law can generally be a good thing for a whole host of reasons identified by other scholars, including legal innovation in corporate law, responsive lawmakers, and the list goes on. That doesn't mean that unrestrained competition should be unconditionally celebrated. I think in terms of why now, I think there are several developments, both on the demand side and the supply side, that has contributed to the resurgence in competition. I think in terms of the demand side, the current dynamic showcases that there is a distinction between what good corporate law, good corporate governance is, and what influencers and superstar CEOs say what good corporate law might be. And I think the latter, including someone like Elon Musk tweeting, "Never incorporate your company in the state of Delaware," might actually have some impact in the market. And while the traditional analysis assumes the strength of Delaware based on its status as producing good corporate governance rules with expert judges, the market may not actually reward good law in all circumstances. And shareholders who ultimately decide whether to approve corporate reincorporation out of Delaware might give credence to opinions of superstar CEOs like Elon Musk rather than listen to the recommendation of corporate law counsel that have really traditionally played a role in the corporate law preferences of firms. We've also seen a shift on the supply side. I think the current market dynamics showcases that state lawmakers care much more about just maximizing franchise taxes or revenues generated from annual fees. The conventional wisdom for decades was that no other state other than Delaware is really small enough to go after a revenue source that's really too small to care about as a large or even moderately sized state. It's for this reason why scholars have called the charter competition story a myth, or at best a leisurely walk, meaning that it's a weak competition. But arguably a state like Texas entering into the market is an illustration that states actually do care more about just maximizing franchise taxes, and that might be a good thing. We've also seen international competition. And this is something that I've written about 4 or 5 years ago in a series of papers called Delaware's New Competition and Delaware's Global Competitiveness. In recent decades, judges in both federal and state courts have extended the internal affairs doctrine to apply in the international context, meaning that foreign nations like the Cayman Islands and the British Virgin Islands can and have competed in the market for corporate charters. So companies like Biohaven, Herbalife, Helen of Troy are American companies that are now being governed by the corporate law of foreign nations. And the full knock-on effects remains to be seen, but I think one interesting aspect of this new charter market that has not really gotten the attention that I think it deserves is that charter competition, with all of its promises, may not necessarily result in a model of corporate governance that reflect shareholder primacy, but in reality may usher in multiple strands of shareholder primacy as it relates to profit maximizing illegal behavior. And it might be for this reason why we're seeing a significant divergence between a jurisdiction like Delaware and a jurisdiction like Nevada when it comes to legal compliance obligations.
Professor, are there things that institutional investors can or should be doing to push back against this apparent new race to the bottom in corporate law to better protect shareholder rights from being eroded?
Absolutely. And in some respects, redomestication requires votes, and institutional investors can exercise significant voice through traditional means of corporate governance, which is to vote, engage in discussion with management, or simply not invest in corporations that might offer seriously deficient corporate governance rules. And it's also worth remembering that even when a company is a Nevada corporation or a Cayman corporation, perhaps for benevolent reasons, and I've written about in the past that this might not just be a pure race to the bottom, there are good reasons why a company might prefer these other jurisdictions, it's worth remembering that there are shareholder protections that can be contractually bargained through charter amendments or bylaw provisions that customize corporate governance. After all, most of the lax rules that we observe in Nevada are default rules, meaning that firms incorporated in Nevada can contractually provide higher or Delaware-like or Delaware level protection for shareholders. So let me give you an example. I think a really good case study is a company that is currently seeking to reincorporate from Delaware to Nevada, which is Fidelity National Financial, which is a Florida-based title insurance and settlement services company. It's not a small company, it's a Fortune 500 company. And interestingly, the board of the company recently approved a proposal to redomesticate the company by conversion from Delaware to Nevada, and a similar proposal to reincorporate to Nevada was submitted last year, but did not reach the level of vote required to approve the redomestication. And according to their proxy statement from this year, the company engaged in discussion with, quote, certain of their stockholders. And from that discussion, the board learned that there is a desire to preserve certain stockholder rights that are currently in their Delaware charter. And since the board continued to believe that there are important reasons to go to Nevada, including, at least to them, cost savings and avoiding opportunistic litigation, they simply updated the proposed Nevada charter to preserve certain stockholder rights under their existing Delaware charter. For our purposes, this is super interesting, but because their updated proposed charter makes clear that limitations on individual liability afforded to their directors under Nevada law does not apply to any breaches of fiduciary duties that would either constitute a breach of duty of loyalty or involve acts or omissions not in good faith, or which involve intentional misconduct or knowing violation of the law, or ones that result in transactions from which a director or officer derived improper personal benefits. So it's just an illustration that shareholder rights are things that can absolutely be contractually bargained for, even if a firm chooses to incorporate in a lax jurisdiction.
Professor, what role do you think the federal government, including the U.S. Securities and Exchange Commission, can or should play, if any, in addressing this apparent race to the bottom in corporate law?
So I think most importantly, I think it's important not to overreact and to resist the temptation to usurp the corporate lawmaking authority given to states and sort of messing too much with the charter competition. Notably, the federal government has a pretty poor track record of producing corporate law, CEG, many of the provisions of the Sarbanes-Oxley Act. It's also worth remembering that corporate law, which really must adapt to rapidly changing business environments, is likely ill-suited for federal law, which is difficult to amend. Solutions instead, in my view, might lie in a modest adjustment by public enforcement authorities at both the federal and state level that investigate and prosecute corporations for violating external sources of law, including environmental laws, antitrust laws, consumer protection laws. After all, when it comes to corporate lawbreaking, both external enforcement by government authorities and internal compliance structures within corporations influence the tendency of corporations to violate the law. So currently, public enforcement agencies are largely agnostic as to the firm's place of incorporation. So when I talk to my friends at the DOJ or the US Attorney's Office, this is something that they just do not consider or even think about. But we know that the firm's place of incorporation can vastly influence the compliance tendencies of any given corporation. And this doesn't mean that we have to categorically treat the place of incorporation as an outcome determinative factor or necessarily go after these firms, but but it can be a prima facie evidence of the firm's internal compliance culture. And that's something that could be infused and implemented simply by updating things like the Department of Justice's evaluation of corporate compliance programs, which offer guidance on factors prosecutors should consider when assessing the adequacies of corporate compliance programs during criminal enforcement actions. And I think this is the kind of soft nudging that might be a modest but an important mechanism to preserve some of the well-documented virtues of charter competition while serving as a guardrail against jurisdictions offering a body of law that completely eliminates legal compliance mandates, along with sort of eroding some of the other protections that are afforded to shareholders under a traditional corporate governance model.
That concludes our podcast episode. On behalf of the Council of Institutional Investors, I want to again thank my special guest, William J. Moon, the J.B. and M.K. Pritzker Family Foundation Distinguished Visiting Professor of Law at Northwestern Pritzker School of Law, and the Edward M. Robertson Professor of Law at the University of Maryland Carey School of Law. If you have any questions or comments regarding this podcast, please feel free to contact me at Jeff, that's Jeff, at CII.org. Till next time, I'm Jeff Mahoney. Thanks again for listening to the Voice of Corporate Governance.
Thank you for listening to this episode of The Voice of Corporate Governance, brought to you by the Council of Institutional Investors. The Voice of Corporate Governance is a free, non-sponsored podcast that highlights critical developments in corporate governance and other important issues affecting institutional investors. The views expressed by those interviewed on the podcast do not necessarily reflect the views of CII or its members. For more information on CII and its policies on corporate governance, please visit our website at www.cii.org.